SJC-13720, Commonwealth versus Jorge L. Santana.
Okay, Attorney Riley.
Good morning, Your Honors, and may it please the Court, Casey Riley on behalf of Mr. Santana. At a young age, I told my parents I had, in fact, eaten my vegetables. It wasn't until years later that I learned that tomatoes are actually fruit and not vegetables. At the time, I didn't know that I wasn't being accurate, but as I stand here today, I can tell Your Honors that I certainly had not eaten my vegetables. Just like my younger self, plea counsel here answered yes. He told the court that he had discussed immigration consequences with his client. His one-word answer certainly didn't tell the court the whole story, because years later, he too learned of his mistakes. He learned that he hadn't discussed the specific and accurate immigration consequences with his client, and he signed an affidavit there too.
What do we do with the citation to Clark in the record, in the judge's finding that he gave Clark warnings and experienced counsel? Because this doesn't happen in a vacuum. All these immigration consequence cases are going on. The time Clark is certainly significant. And if you read Clark, it has everything in it. So what do we do with that finding?
Sure, and I think I spent a long time really thinking about that specific question. And obviously the motion hearing, Judge Swan asked me that as well. What I think when we look at that sort of wording, I think that really just goes to the heart of what's on the back of a tender of plea form as well. It's really just making sure that plea counsel had a conversation with their client about the immigration consequences. There was no specific question about the substance of that conversation.
Could there have been?
I don't know if that's necessarily an appropriate question. Sure.
You referenced the plea call, the plea warning at the end, and it has the practically inevitable language in there as well, correct?
It does have that, but I think that the case law has been quite clear. Commonwealth versus Henry comes to mind, and that the tender of plea form in and of itself is not sufficient. That
If this all goes, so we have that, we have a citation to Clark in the plea colloquy, and a judge noting Clark, right?
he does know Clark. Obviously, I can't change that question was asked. Sure. But what I think here is that we still do not have any facts from the plea colloquy as to what the substance of that conversation was between Attorney Ortiz and his client. So that's really the question here, and I think that's why remand for an evidentiary hearing is particularly important and would be necessary in this case.
Can I ask about Clark? Because I just glanced at Clark again, but I thought Clark only had the subject to deportation language. Does it have the like the Jesus language about it's inevitable? I can't remember.
It does not. So Commonwealth versus Clark is exactly what Your Honor said. So it says subject to deportation. I think Commonwealth versus De Jesus is when the court clarified those sort of specifics that need to be given to a client when we're talking about an aggravated felony conviction.
So if you give even if you'd actually sat there and was reading Clark, it wouldn't have that, it's inevitable you're getting, we're not letting you back in the country. And again, I haven't read through Clark closely again, but I thought Clark just had that sort of generic language in it.
It does. It quotes largely Padilla versus Kentucky, and what I think of Clark is the sort of seminal case for Massachusetts when applying Padilla versus Kentucky to Massachusetts cases and talking about sort of then I think it's the beginning of a progeny of cases. It's not until Commonwealth versus De Jesus when we get to the more specifics of aggravated felony convictions, and that's the presumptively being deported, that's the mandatory detention, as well as the not being eligible for any relief in immigration court.
Clark triggers Padilla, essentially, right? And says you have to, right, basically says you have to do more than the statutory warning. That's just not enough.
Sure, I think that Clark says that you have to have that conversation, and you need to talk about whether or not you're subject to deportation. I think that is exact wording from Commonwealth versus Clark. It's not until years later when we get to Commonwealth versus De Jesus where the court talks about more expanded warnings. I think.
Right, but then the colloquy that happened in this case, the judge gave the De Jesus, he gave the practically inevitable language in the colloquy, correct?
colloquy in and of itself was the 29D warnings that are given in every single case. The only difference between the 29D warnings that were given in this case and everything else is that the Justice, Judge Swan, in this case asked, did you comply with Commonwealth versus Clark, which I would submit to this court is essentially the same thing as the 29D warnings. We're not asking about the substance of the conversation between Attorney Ortiz and his client, Mr. Santana. We're asking, did you have a conversation with your client?
Well, let me ask you a different question.
Sure.
Then. So you're in front of, and you talked to Judge Swan about, you've had conversations with Attorney Ortiz. And at some point during the hearing, he talked about, did you just send this affidavit and did he just sign it, or did he have some kind of, some activity in the iterative process? So the burden is on you to demonstrate that there's an issue that needs a hearing. So when you stand in front of us and say, well, he didn't tell us and put any meat on the bones about what those conversations were or were not, that was something that you could have done when you were doing the affidavit and saying, you've got to get into what you actually said and what you didn't say. But you didn't do that. And the affidavit in front of Judge Swan didn't have any of that. So where do we get that he abused his discretion based on what was in your control to provide to him?
Sure, and I think where we get to the abuse of discretion is that it's not based in fact. What I think we have is an affidavit signed by Attorney Ortiz, whether or not drafted by myself, or whether or not it was ultimately signed by Attorney Ortiz. That's the person who ultimately signed that. He had every power to make every sort of edit to that documentation. So when Attorney Ortiz signed that affidavit as an officer of the court, as an attorney who was still practicing, he was representing that that was the truth. It was the first time that we had a factual allegation that he did not, at the time of the plea colloquy, know the specific immigration advice. I actually think that he states, I did not know.
I don't disagree with any of that. I'm getting to the point of your showing that we need an evidentiary hearing on this.
Sure.
And I'm getting to that Attorney Ortiz would have provided the court with what he did to be able to have some measure of doing a compare and contrast as to what De Jesus says you're supposed to do. And he didn't do that. And part of that is one of the reasons why I was ostensibly, Judge Swan said, we don't need a hearing here. I don't credit this.
So I actually think that Attorney Ortiz does cite De Jesus in his affidavit, Your Honor, but what I think Your Honor really is getting to is exactly the reason we do need an evidentiary hearing in this case. We don't have specific factual findings from the time of the plea colloquy beyond the affidavit of the defendant, which the judge simply discredits as being self-serving, which candidly every affidavit of a defendant is self-serving to some point. But we also have an affidavit from plea counsel who is candid. And I think if you look at that affidavit, he says, I gave some advice, which is something that we've seen in other cases before this court. I gave some advice, but not all of it, specifically differentiating between Commonwealth versus De Jesus. He cites that in his affidavit, which I think points to, I didn't have that specific conversation about presumptive deportation, about mandatory detention, ineligibility for relief, but all of those questions could have been resolved in an evidentiary hearing.
But why wasn't it incumbent upon the defendant who has this burden to say in plea counsel's affidavit, I acknowledge that I thought I gave a fulsome consequence discussion to the defendant per Clark. I now know that I didn't per De Jesus, and the reason is blah, right? What is it that I didn't say? Because De Jesus is about counsel, I think, saying you might be eligible for deportation.
That is what I think that's what plea counsel stated in De Jesus prior to the motion for new trial, yes. I think he said that, I think the wording that plea counsel said in De Jesus is that you are eligible for deportation.
Right, and so there seems to be some daylight between eligible for deportation, which was the De Jesus problem, which is not the problem here. The problem here is plea counsel says you will be subject to deportation. And I don't know what the difference is between being subject to deportation for somebody in Mr. Santana's position versus what it is that you now think he should have said.
Sure, I think Commonwealth versus De Jesus actually talks a little bit about this. that in the end, it's on the obligation is on defense counsel to explain the immigration consequences in a way.
To the particular person. That's why I asked in my question, why for somebody in Mr. Santana's position, these other more detailed descriptive things would have mattered when, as somebody who was now just, a legal resident in the United States for 3 years, with his family here for much longer, why it would have mattered to Mr. Santana to have known you're not just subject to deportation, but subject to automatic deportation or whatever else it is that you think that counsel should have said.
Sure, I think there's two parts to your Honor's question. The first part I'm going to answer sort of quickly because I think it goes more towards prejudice and special circumstances. And I apologize if I'm misunderstanding your question, but when we're talking about the language that should be used to the defendant, it should be clear, and it's in language that the defendant should understand.
Right.
So when you're talking about subject to deportation, I think Commonwealth versus De Jesus is clear that it needs to be something about automatic.
But no, De Jesus was about an attorney who said, yeah, you might be eligible for deportation.
And I think that subject to is similar to that. That's where Commonwealth.
That's my question. Is it?
I interpret that to be this.
But why?
Because I think that that's the difference between something like Commonwealth versus Clark and then the clarifying language that we get in Commonwealth versus De Jesus. I think that that's the differentiation there. Subject to is also subject to when? I don't know. There's questions, and I think that there's some sort of speculation.
So you're saying plea counsel needed to tell him he was subject to when?
No, I think that I am saying that plea counsel needed to tell him, you will be deported. You will be presumptively deported. If immigration officials seek your detention, you will be detained and you will not be eligible for any relief in immigration court. You will lose your legal permanent residency that your wife petitioned for. You will lose the chance to remain in the United States with your children and your wife, both of whom had legal status in the United States.
But isn't that incumbent upon plea counsel to explain to the judge in the affidavit? I know you talked about Clark, which was essentially the same crime, where Clark said that this crime, the same one, is subject to automatic deportation. Wasn't it incumbent upon plea counsel to raise that question in the affidavit, and where the trial judge is the motion judge and says, hey, you told me per Clark you gave him the instructions? It seems like there needs to be some explanation there.
Sure, and I think that goes again, and I know this is very similar to what Justice Jorge had asked me as well. I think at the end of the day, that's why we need an evidentiary hearing. The burden of the defendant is not to prove that he is deserving of a motion for a new trial. He needs to raise a substantial issue and needs to have an adequacy of showing. Here, I think where we have a defendant's affidavit, albeit self-serving.
Yeah, let's focus on the plea counsel.
Sure. We have a plea counsel who is admitting to ineffective assistance of counsel. I think that by case law, is enough to merit at the least an evidentiary hearing.
You want us to overrule lists in the other cases that allow a judge to discredit an affidavit?
I don't think that so I think that the discretion is not boundless. It's not limitless, Judge.
Well, we
said you can do this, but you need a reason, and the judge gave a reason. You may not like the reason.
Right.
He gave a reason.
And we just said it again in Goparian about 2 months ago, where we did say a judge abused his discretion for not having an evidentiary hearing. But we said that the presumptively they get to do this if they give you a reason why. And again, I think you seem to be moving the goalposts here, because we're not conflating whether or not he should get a new trial with the showing that you need to make to get a hearing. And in that showing, we're not asking you to prove it in the affidavit. We're asking you to make the showing that you deserve to have a hearing. And if you're not giving us the information, or not giving the judge the information to do that, how is that an abuse of discretion to say you don't get a hearing?
Well, I guess where I disagree with the court is that I think in the affidavit from Attorney Ortiz, there is a showing of that. He admits that he gave some advice, but not the advice that he perceives is effective at the time.
Yeah, but I'm not talking about the gloss of advocacy. I'm getting back to, if you combine what Justice Wendland and I've been saying, that you've got to give the information. Okay, you've got to say, here's what the circumstances were, here's what I should have done, and here's what I did not do. You can't just generally come in and say, I didn't comply with De Jesus. That just doesn't tell a judge anything in order to him or her to exercise their discretion one way or the other.
And I think ultimately when a plea counsel signs an affidavit, and I think that the plea counsel signing of an affidavit admitting to ineffective assistance of counsel should carry some weight before the court.
He's more specific, right? In his affidavit, he says, I told him he was subject to deportation. But this gets back to Justice Wendland's point about there's Padilla's counsel, excuse me, De Jesus' counsel said you were eligible for deportation. He didn't say it was subject to mandatory deportation. Are we in a crack in the law here? Because we have a plea counsel admitted he said he's subject to deportation, but we haven't really decided a case exactly like that, have we? Where the difference between eligible, may be deported, subject to, and subject to mandatory deportation, which is now the De Jesus line. So are we in that crack?
Sure, so I can't think of a specific case off the top of my head where this court has talked about the specific word subject to deportation beyond Commonwealth versus Clark, where that wording is directly used. But I think at the end of the day, it's the meaning that we can get from that paragraph in Attorney Ortiz's affidavit, where we get to, I explained some portion of this, but I didn't explain the fact that he would be losing his legal permanent residency without any available relief in immigration court, thereby effectively losing his chances to remain in the country with his family.
But he doesn't actually say that, right? Plea counsel doesn't say, I remember talking to Mr. Santana, and I told him that he would be subject to deportation, and I now know that advice is wrong. He says, at the time that I was working these kind of cases, I would have told the typical defendant the following, and I now understand that such advice, whether or not I gave it to Mr. Santana, I'm not averring to, would have been deficient. And so in the absence of the counsel, sorry, Justice Caffer, if I could finish. In the absence of counsel having a specific memory, why is it an abuse of discretion for the judge to say, I have a specific memory, I took notes at the time, and he assured me that he had gone over the right consequences per Clark.
Well, I think all of these are appropriate questions for an evidentiary hearing where—
Does he have to do that when the counsel's affidavit is just like, generally, this was my practice, I understand that that's not right?
I would suggest that he should, because he's admitting to the fact that he provided—
I know that you would have had the evidentiary hearing. I understand your position as to that, but why is it an abuse of discretion, given the broad discretion of the trial judge, who's the motion judge, in assessing whether or not he needs to revisit this?
Because I think that there's a substantial issue that's raised in the affidavits that's not contradicted. And even Judge Swan in his decision says this, it's corroborated. The defendant avers that he was provided with ineffective assistance of counsel, and that is corroborated by plea counsel's affidavit.
He says specifically, paragraph 5, at the time Mr. Santana's pleas, I would have explained to him that he would be subject to deportation, but that he would, but not that he would be automatically deported, mandatorily detained by ICE and ineligible. So isn't that a factual allegation?
That is a factual allegation. The discreditation of that specific part that is not in, that's based on a factual error from the previous plea colloquy is why I think there's a need for an evidentiary hearing, and I apologize if I'm—
No, I'm not sure what the answer is about whether you should or not. I'm just trying to pin down what he said he said. And that's what he said, right?
Yes.
Right.
Can you address Commonwealth versus Petite Home 2019 case?
Unfortunately, Your Honor, I'm not familiar with that case, and I'm happy to submit something in writing.
Yeah, would you please? Because in that case, we said that the practically inevitable warning is not a substitute for the 24D warning. And we said that generalized warning subject to deportation is what's informative.
Of course, and I'm happy to submit something in writing after today.
I'd appreciate it. Thank you.
Thank you, of course. And if there's nothing further, I see my time's ended. Thank you so much.
So it's 482-775.
Thank you.
Thank you. Okay, Attorney Cohen.
Good morning. May it please the court, Jennifer Cohen for the Commonwealth. In this particular case, where this judge was both the motion judge and the plea judge, he did not abuse his discretion in denying the motion for new trial on the papers. While the issue raised by the defendant was certainly serious, it was the defendant's burden to submit sufficient credible evidence to cast doubt on the issue of the warning that was given by defense counsel during the plea.
I'm wondering, and this is not strictly speaking, if I recall the facts correctly, a case of deportation, but rather of denial of reentry. And I take it that there's nothing to indicate that the defendant was advised that that as a consequence of his plea, he may or would be denied reentry into the United States.
That's correct.
So if all of that is correct, then why is there not a substantial question meriting an evidentiary hearing? I mean, right, it's just like this massive disconnect between the actual facts and the warning that was given by the judge and the warning that was given by the attorney.
Yes, Your Honor. So I believe that my answer comes down to the fact that the plea counsel's affidavit didn't provide sufficient information. I understand your point that if we agree with...
He was denied reentry.
Correct.
Right,
that
so
he
that's
didn't give
that's
that.
the prejudice piece
Sure.
of this, right? And so what the affidavit says, and I didn't even really see the judge in his findings deal with this reentry piece, but in the affidavit, and I'm sorry, I just don't have it in front of me, I think I'm confused by the affidavit because the affidavit is not in the active voice, it's in a conditional voice, and that always throws me off. But he says, I would have advised him of that he would be subject to deportation. Okay. But have we ever said that the word deportation encompasses denial of reentry?
No, Your Honor. And my understanding, I know obviously we're talking about Clark to De Jesus.
Yeah.
I'm not sure that even De Jesus explicitly says what warning counsel needs to give. I think there's a footnote 5, that says these things, these considerations are so incredibly nuanced. Someone might be a refugee, so we're not going to tell you exactly what you have to say. So I think there probably is a bit of a hole there as far as what, at a minimum, needs to be conveyed by counsel in these sorts of circumstances.
But the reentry warning is encompassed in the 29D warnings. And the docket denotes that he was given the 29D warnings.
Yes, and it is my understanding that the 29D warnings don't suffice to substitute for the good advice of counsel, but
Understood. I'm speaking specifically as to Justice Wola-Hojan's concerned about was he warned that he may be denied reentry?
Yes, so I agree with Your Honor. He was advised by the judge, and I think that the court can take that into consideration as part of the prejudice consideration, but I'm not sure that if we take the affidavit as true, we can say that he did actually give correct advice here, notwithstanding what the judge said.
But if he didn't give advice that the defendant needed, why wouldn't we need an evidentiary hearing?
So I suppose, notwithstanding my argument on this point, I would still argue that the affidavit didn't sufficiently raise credible information to cast doubt because it is in this passive voice. There's no indication that defense counsel, beyond his conversation, plea counsel, beyond his conversation with appellate counsel, did anything to refresh his own memory. We know that the judge was able to listen to the plea colloquy. Certainly that was available to defense counsel.
Does that mean that any time a defendant, the prior defense counsel doesn't remember it's too bad for the defendant?
No, but I would say that perhaps this affidavit could have been worded in a more definitive way so that maybe, I'm not saying it would have been, but potentially an evidentiary hearing could have been warranted. It could have been worded to say, my normal practice was this. I only learned in 2020 that I may have been giving incorrect advice. Something to so that the motion judge could say, okay, this seems like this person has attempted to familiarize themselves with this particular situation. And I don't think that the judge who did take the steps to familiarize himself with that plea was required to believe the plea counsel's affidavit where it wasn't apparent that he had refreshed himself in any way with the facts of
And
the
that's what we're gonna hang everything on?
Sorry, go
You
ahead.
just, yeah, I'm not sure I get that.
May I ask a question about the judge's decision? Is it your view that the judge engaged in the prejudice analysis, or that the judge focused on first prong?
The first prong, Your Honor.
That's what I think too.
Yes. I don't think there were any findings as to prejudice.
Sorry, are you done, Justice Whalen? I'm confused by, it seems like the affidavit and the judge are on the same page. The judge says, okay, Clark has that subject to deportation language. The affidavit also expressly references subject to deportation and draws the distinction between that and Padilla. I guess I'm not and why is that? Is subject to deportation alone enough? I mean, I don't know what that means, and I've been doing this a long time. So how is the criminal defendant going to know that's enough?
Well, I think it would go a long way, perhaps, for this court to provide minimum, at a minimum, what defense counsel must say.
Well, we've been doing, I mean, we're DeJesus, and Justice Gazianos brought up Petite Home, which I wrote, but I can't remember at this point. But what have we said?
I think that the language used is practically inevitable. I think that it's...
That's not this language.
No, it's not. But again, I think...
But we excluded the practical. We had that in our rules of criminal procedure, the practically inevitable. In Petite Home, we said, whoa, and we took it out.
But I think that the court, the overall warning has to be accurate if it's clear that you'll be deported. Subject to deportation, I can see...
Exclusion from admission or denial of naturalization.
Yeah, yes. So
isn't this a problem, this case?
Because
The judge thought subject to deportation was enough. The counsel thought subject to deportation was enough. But we've said we need to be more emphatic.
Right, isn't the issue that nobody's an immigration expert on this side of the court, in the state court, and if we say too much, we could misinform.
Exactly. And I would just walk back a moment and say that Clark didn't definitively say subject to deportation was an adequate piece of advice because they never got to analyze any advice. No advice was given in that.
Most of Clark is about retroactivity. It's
Yes.
Well, and in Clark, counsel failed to discuss whether or not
Yeah.
the defendant had any immigration concerns whatsoever.
Yes. We never got to analyze the contents of.
So what words are necessary now that you're asking us to do that?
Well, I would argue that the words potentially from the 278-29D warning would be at a minimum what counsel should say. And then of course you should tell.
But the 29D wording importantly contains if, I think repeatedly. So it's not advice in any way, shape or form. It says.
I understand that, Your Honor. And I think of course we run into the problem that we have. I think you first have to ascertain if someone is a citizen, and if they are not a citizen, then something akin to the 29D warning. But I think we're always in kind of a bad position, not really knowing the baseline facts behind the scenes.
Can I ask you a question about the discrediting of the affidavit? So there's been floated a number of bases today on the basis of which potentially one could discredit this affidavit, such as the use of the word would and so forth. But the judge actually cited a specific basis for discrediting the affidavit, which is that in the judge's view, the affidavit was impossible to square, apparently, with the attorney's averment on the record at the plea colloquy that he had discussed immigration consequences per Clark with the client. Why are those two things in conflict? Why is the affidavit not, why are those two things necessarily in conflict for the reasons given by defense counsel?
Yeah, so I do understand, being a human kind of puts you in the position of you only know what you know, or you only believe you're right until or unless you're proven wrong. I think that's true of most answers that we give. And within the context of a courtroom, we've decided that somebody who's under oath or someone who is an officer of the court gives an answer to a question, especially something that's pointed like this, have you advised pursuant to Commonwealth and Clark? And granted, there may be a better case that the judge could have cited, but I think he narrowed down to the issue here. And I think he has to accept that answer pursuant, obviously, or sorry, caveat being, all of the other observations that he's making during this colloquy. He has to be allowed to accept that answer.
Of course, that's not the question. Of course, he could accept that question. And then counsel's affidavit says, I did say he was subject to desertion, but I didn't get into all this other stuff. So what are you defending that the two are actually in conflict as a basis for denying an evidentiary hearing here?
I suppose I'm arguing that we have to accept this other answer unless or until sufficient credible evidence speaks to the contrary. And I'm just arguing based on this particular affidavit and these facts that this was not enough to rise.
I asked specifically, are you defending the judge's decision to discredit the affidavit, which I agree was necessary, on the basis of the fact that it was in conflict with what counsel said at the hearing?
In these circumstances, yes.
How was it in conflict?
Well, because it was yes on the first hand and a no on the second.
Would you agree that the counsel's answer during the plea colloquy was not necessarily contradicted by his subsequent affidavit? Just as a matter of logic.
I believe it's possible, yes. I believe it's possible.
So that being the case, why isn't that enough to warrant an evidentiary hearing?
I think that
because the judge can then, make the necessary findings to resolve the issue. What's the relationship between the averment in the subsequent affidavit and the representation during the plea?
I would argue that it's not up to the judge to fill in the blanks of the affidavit, that the affidavit in this case, and I understand, the counterpoint to this, but my position is that the affidavit could have been worded in such a way that the judge found it to be credible, in that, again, perhaps the defense attorney could have just said, I listened to the colloquy myself and I remember this client. I think the affidavit in Gordon is also, not, I think it uses conditional language, but also there's a lot more information in that affidavit that would allow a judge to say, oh, okay, this person recalls the situation and there is an actual question here. So I think it's not in every situation where there's a yes and then a no, a judge can just say no evidentiary hearing. I think it's very fact specific. And I think in this particular case, the affidavit just didn't meet the bar for the hearing.
Given that the motion judge decided this on whether there was sufficient warning at all, or the credibility of plea counsel's affidavit, can we decide this on prejudice, or should we remand this?
If your honors, well, I think it would have to be remanded if you, I don't think that you can find on prejudice. I think we argued prejudice just for whether an evidentiary hearing was warranted in this case. I think it could be remanded for an evidentiary hearing for prejudice and for the first prong of Safarian. I will rest on my brief. Thank you very much.